Good afternoon, everyone. After such a dynamic session, I guess we should move on to certain technicalities now. So, resolution of stressed assets, valuation in IBC, and role of information utility. Indeed, varied topics. We have heard of it, read about it, read about it, yet it is less thought of and looked after and talked about even. We tend to forget that these are the prime which gives the effectiveness of resolution and liquidation in toto. In this session, we shall try covering, if not everything, but somewhat of everything. My first question might sound a little cliched, but it is a topic worth asking and I feel worth answering. Since the time IBC has been operational, there have been numerous amendments, strategies, proposals, suggestions, developments, etc. to strengthen the framework, despite which, in some way or the other, there still remains certain loopholes, lacunas for the complete effectiveness of the insolvency and bankruptcy laws in India. Mr. Deora, Mr. Narayan, Mr. Ahuja, and Ms. Sharma, how effective do you find the current regulatory framework in addressing the stressed assets?
Thank you very much. There was a leak of question paper before this conference, so I've had the benefit of my notes which I'm carrying with me. So I don't think I'm going to be charged for it, nevertheless. You see, the law in every economy or country or sovereign is on the basis of the socio-political, geographical and other considerations, and that's how it develops. So our constitutional preamble in the Constitution which talks about socialist democratic state has had a great influence on everything. As I just mentioned about some UK law changes, the law came in 1986, and we're seeing changes even now. So the legislators, regulators are aligning themselves with the market and ground realities. Something unique is home buyers protection, treating them as financial creditors. It was a need of the structure of the economy. 29A, because we have public sector banks, 70% of the lending is from public sector, whereas globally 70% of the lending is non-banking lending, is non-banking financial companies, private equities, distress funds, special situation funds, etc. So in that scenario, when the banks which have public money have to be protected, you need a 29A, which is a very far-reaching section. Needs a review in my view. You have the MSME protection. The world is moving towards medium and small industries to be protected. German laws are worth noting in this because how they protect the German medium and small scale industries, a country that thrives on medium and small scale industries. When COVID came in, UK came in with a regulation that the tenants will not be ejected for non-payment of rent. And that continued till probably last year or a year before last. Don't remember the exact date. Because UK, they say, is a country of shopkeepers. So therefore they have protected the trade and commerce of shopping, of retail, high street retail, sub-high street retail by providing legislative changes. The new focus everywhere is pre-packs. It's not worth putting companies into insolvency and liquidation. Capital must be preserved. Capital is a scarce resource for the globe as a whole. Capital is also environment, is also human power, is also technology, is also intangible properties, leave apart fixed assets. So all jurisdictions are today working on how effective is a pre-pack and least intervention of the court. It is also linked to synthetic insolvencies, which probably is a different subject. So synthetic insolvencies are being seen in the world, but we have not seen them here as yet. So the world would change, the changes would always be there, and the more the changes we make, looking at the ground realities, looking at the socio-economic structure of the country, we are better off. So if one has to put a one-line answer, yes, it's been fairly effective considering it's a new law. We're all learning, and there's a lot of learning which sits outside of the country. We should engage more with the outsiders, with the global agencies, multilateral agencies, with other countries, with the insolvency boards outside India, with judicial authorities outside India, and see that how we can make further changes. I don't want to prophesize on anything.
Should I go next or? Yeah. So, sir already told that the question paper was leaked, but we have some students who get more nervous or do more research when we have the questions, right? And it's more natural for us to just do it simultaneously. So I believe IBC definitely has made a lot of changes. The question is, what are the loopholes? Maybe a lot of amendments are coming. Is it effective, not effective? IBC definitely has brought in a change in attitude and behavior, if you ask me. Very recently in the budget, the finance minister also stated that apart from what is resolved, there is also a bunch of large cases which got disposed of without admission, because that's a fear in the promoter's mind that they will lose control over their loved asset. So that's one very good behavioral change which is there. IBC was brought in because other laws were not working as intended. They were taking like 6 to 8 years. You take SARFAESI, you take RDDBA Act, SICA, everything was like taking a lot of time. That's why they brought in IBC. So I can say a couple of things, like one is timelines. At least we have a certainty on timeline, whether that's getting achieved or not, it's a different story, but we have some certainty given the code. There is an adjudicatory body. So banks are happy that court's blessings are there on a plan. So I have a different opinion on pre-packs, because very recently RBI governor also said pre-packs are not a success because the bankers have a fear of voluntary haircut. So they don't want to be questioned 10 years later on why something was voluntary allowed by them. But in CARP, that case is not there. Banks are okay with a CRP process. And apart from that, there is a lot of innovative structures which is allowed in a resolution plan. Since Sir said it's evolving, it gets a lot of good innovative ideas from resolution applicant. You get reliefs and concessions built in, you get a lot of waivers built in. But there are some complications also on which clarity is not there. Taxation is one concern. Accounting of how post-resolution activities have to be done is one concern. So definitely good changes. Some loopholes are there. But I believe if you compare it with the previous regime, this has definitely got a lot of success. That's my 2 cents on this subject. Thanks.
Mr. Ahuja?
Yeah, thanks. So if we see in the last 7 years journey of the IBC, and today when we see the financial institutions, they are not much inclined towards the IBC. The primary reason that we can able to understand while interacting with them is the high CRP cost. They are not comfortable incurring significant cost to the process. The objective that this financial institution have is the recovery instead of the resolutions. So we need to educate them. Definitely, as Mr. Badri has just mentioned, this process is much better than the earlier processes, are much better. Yes, it still has a lot of inherent limitation and disadvantages. The regulators, the lawmakers are continuously making a lot of changes in this. And surely if they can absorb this extra cost, it would be better, helpful in the economy and in the long run. So in the last line, I would just like to say, definitely it's a better one. And if we're going to have a more focus, insight in the resolutions, it will be better for the entire economy and the institutions as well. So these are the 2 cents on the beginning, please.
Ms. Sharma?
Yeah, regular amendments in the IBC is making the IBC more functionable and more acceptable in the economy. We have to find out the gray areas which we are facing nowadays, and we have to resolve over it. The changing role of the valuers, the accountability of the valuers, and the involvement of the valuers with the COC has made some more changes in the IBC, and which is welcoming, accepted by all. And it is, I think, good, and it will improve the working of the IBC, and basically the confidence of the public on the IBC rule and the process will increase.
While we are talking about advancements and progression in IBC, we obviously cannot forget NeSL. NeSL, which is India's first information utility, is obviously a key pillar other than obviously our adjudicating authorities, IBBI and insolvency professionals. NeSL was primarily established to be a repository of information for the creditors and the debtors. In that aspect, Mr. Roy, I request you to kindly shed light on the role of information utility in the IBC ecosystem, and in what ways has it improved its efficiency and transparency of the insolvency resolution process?
Yeah, thanks, Ankita. In fact, in my opening address, I spoke about the elephant in the room and some data which does not really get published. That is how much time it takes for admission of an application. And gradually, the AA has been sensitized, the record of default of the information utility is being used. But in the proposed amendments, which was of course part of the MCA discussion paper in January 2023, it stated about the increasing role of the information utility in facilitating admissions, and admissions takes place with less delay. recently around in May 2024, IBBI published a discussion paper on how to make this process more effective. So there are a couple of amendments which have been proposed, mainly to facilitate the process of admissions. So I'd just like to, give broad details of few of them. The first and most important amendment proposed in the regulations is that the record of default which the information utility is going to henceforth issue, it will be after due diligence. Due diligence on what? Due diligence on the existence of debt, default, security, and a few other factors. So that's the most important part. So now the creditors need to give details, documents, evidence of proof of debt and default to the information utility if they want to use the record of default as part of the application to the AA. So that's the first part. Second part is when the information is submitted, information of default is submitted to the information utility goes through process of authentication. It presents information to the debtor. It gives an original message plus 3 reminders at a space of 3 days each. So now IBBI says that instead of 3 days, please give 7 days each time to the debtor, giving him an opportunity to accept or dispute the information of default. Now the natural question arises, this will increase the time to get the record of default. In the ideal scenario, today it takes around 14 days because 3 reminders in the space of 3 days each. If IBBI regulations come into effect, it will actually take almost, as per our rough estimate, it will take almost 32 days to get the record of default from the information utility. Why have they done this? They have done this because they feel, IBBI feels, that it's better that the information utility takes time, or rather give the debtor adequate time to respond, or maybe regularize the default or come to a settlement with the debtor. So give them adequate time, and even after such time is given and the default is not cured, then the record of default will be issued, and that too with adequate proof of debt and default. So idea is that a preliminary due diligence on the debt and default will be done by the information utility so that it makes the task of A much easier. And a couple of factors which facilitate this. One is all information to the information utility submitted by way of digital signature. So it's admissible in a court of law. Now, another important amendment which IBBI has proposed is that if the default when it's reported by a creditor, so debtor has the right to dispute part of it. So today what is happening, debtor often disputes the entire amount, but sometimes he may be agreeable to accept a part of it. So the regulations will now provide that he can dispute only part of it, and the remaining part of it he can accept. So what will be the benefit? At the end of it, it is the IP who adjudicates, IP who collates the claims, and the AA will finally decide. At the point of admission, you only need to ascertain whether the default is more than 1 crore. So if the information of default is filed for say 5 crores and the debtor says, look, I accept for 2 crores, remaining is dispute. So the AA will say that yes, 2 crore he is accepted, ROD is issued, so based on that, admission can happen. So these are some of the proposals which are being proposed by IBBI. These are only part of the discussion paper, but it is expected that it will help the insolvency resolution process. Now, Ankita, you also use the word transparency. In fact, the BLRC used the word information asymmetry and how the information utility helps in reducing that. So I'll just take a few minutes to dwell on that. When a default is authenticated, that means either the debtor accepts it or he's given an opportunity to accept or dispute and he does not exercise that option. So consequent to that process, the default is treated as authenticated and all creditors are alerted about the same. So the default is only to one creditor, but all creditors come to know of this. So that's where information asymmetry is reduced. All creditors become aware that there's default and they can take measures to protect the interest. So that is one important function which the information utility performs as part of its functions under the code. So I can speak more, but I think I will give opportunity to others. Come.
Thank you, sir. Now, when we talk about stressed assets, we cannot forget or we cannot ignore ARCs. ARCs play an important role in reducing the stress for the banking sector and further promoting the financial stability by resolving the NPAs. Now, even though after the October 2022 notification whereby the RBI gave a welcome pathway to the ARCs to become resolution applicants, there are still certain caveats to be kept in mind. For example, in Suparna Dhawan's case, the Honorable NCLAT, and I quote, has affirmed that resolution applicants should not decrease the activities of the corporate debtor, but revitalize it, and further stated that instead of adding value with the purpose of selling it, the resolution applicant should seek for insolvency resolution. Now, in that context, my question goes to Mr. Deora. What role do ARCs play in the resolution of stressed assets? What can be done to enhance their effectiveness? And my follow-up question to that would be, pursuant to RBI's allowance of ARCs to act as resolution applicant, what is the probability of collusion or what deterrent or silver lining ought to be kept in mind while ARCs intend on being a resolution applicant to maintain transparency?
Yeah, it's a pretty wide question. I'll make some attempt. The basic maxim is that capital has to be preserved, as I said earlier. Value has to be given to everything. Even if it is loose sand on the street, it has value for something, for somebody. So how do we monetize, discover what is to be monetized, and go about recovering for the stakeholders? Because mistakes will always be made, advertently, inadvertently, circumstantially, or otherwise. So ARCs was a step in that direction because of public sector banking. We wanted some mechanism whereby expert service can be developed, expert knowledge can be developed to turn around business. Insol International, the international organization, has got 11,000 members. Turnaround Management Association has got another 11,000 members. More prominent in the US and in Americas. Not so much in the rest of the world. So turnaround is more important in my view because that's a pre-insolvency exercise. Expertise is required there and that's where ARCs have to or should have developed themselves. Takeover of management, stripping of assets should have happened together. Receivership is one exercise which should have been there in the law because without receivership, you cannot make a success of insolvency. Not that everything is resolvable in the same manner when you have multi-class assets. But ARCs have done a fair amount of good job in terms of developing that expertise over the last decades, as I've seen myself. And now the time has come that they should come in as investors and risk takers, not as mere 2.5% investors and charging a commission and fee and front end and back end fee. Now, where does it lead you to? It leads you to a point how the West resolved its insolvencies or difficulties. After the oil shock in '74, the first thing that America brought in was junk bonds. If you ask your father's friends that I'm investing in junk bonds if he's living overseas, and these junk bonds were tradable, you could buy and sell the junk bonds, and they had a value which was based on how the values or how the perspective on the bonds would change over a period of time. Then came in Europe. Europe adopted a different strategy that had a loan to equity strategy. So if you look at the European companies, you would find company X owned by a bank Y, owned by a collection of banks called Z, owned by a collection of banks called some Landesbank in Germany or wherever. Now they came in a time there was so much of cross holdings in these banks. Sorry, I'm maybe digressing a bit, but just to make you understand the perspective where we stand and what sort of formula should be applied here. So these banks became conflicted banks in different situations because they had investment in a plastic company directly, indirectly, 2 steps down, or through another bank in which they were investors. So Germany brought in a legislation about 15 years ago which said that banks could swap their equities without capital gains or without tax implications so that the conflicts of interest go away. So each geography has had its own methods of going forward. In my view, the SRs should have been made tradable in the first day. On the book, they're tradable, but who discovers the price? And where is the trading? It's not happening anywhere. If SRs get listed on a stock exchange, just like the bonds issued by a company which could be listed even though the company may not be listed, debt can be traded. Why not SRs be traded publicly? There is a valuation mechanism which is floating behind them. This valuation will get transparency into the management of stressed assets. Now, should ARCs in the first place be resolution applicants? Yes, because they develop knowledge and skill. Loan to equity should be permitted. They should be able to convert their debt to equity. Just see the successful example of Yes Bank. State Bank of India brought in money, saved the bank from distress. People would have lost their monies. Of course, I'm not talking about the tier 2 capital which has still lost itself, yet before the courts. And it's a success story as a bank because depositors, small depositors, advances, they've all been protected and value and equities got created. It's a timing issue. So ARCs would come in and provide that disintermediation in terms of time. They would hold that asset, bring value to the street and come back to life. A serious example of time value, how it changes overnight is the Lehman case, where the bond suddenly, as Lehman fell down, the bond suddenly lost value and the banks went bankrupt. But if those bonds were held for another 2 days, the companies would not be bankrupt. So you do a cash flow test, they're out because they couldn't redeem it. But if they held for 1 week thereafter, the bonds are back to life. So it's a timing issue and ARCs must come in to provide that time input with the money, with knowledge, with capital, and have the ability to run the company through turnaround managers, which is a separate skill which has to be developed as a pre-insolvency exercise. Well, of course, I'll just give an example. In Hong Kong, the government will buy the public listed companies which are shells. So I asked a friend of mine once what you're doing, Ken, these days. He says, I'm buying public shells from the government, cleaning up the balance sheet over the next 2 years and selling the shells off. It's legally permitted. In Malaysia, the same thing happened. When the companies went bankrupt, the government bought the shells and sold off the shells. Because there is a value, you have listed a company. So discover where the value is. ARCs should do that job and they have a good, successful future ahead in my view. Of course, the market will change to special situations fund. The market will change to private equity investors, the class 2 AIFs which are coming in. So it's broadening, but they have a head start.
Can I just add
Please.
maybe a couple of pointers. I agree with sir. ARCs have done a lot of work in resolving stressed asset. And bankers don't want to hold on. ARCs come in, buy their asset, and then they try to recover it. It's very similar to discounting trade receivable concept. Now, 2 issues or concerns which I might say can come up here. One is there is a lack of clarity because very recently RBI came up with this notification that ARC can be a resolution applicant. Why is this lack of clarity? When code itself said financial creditor can be a resolution applicant, ARC when it buys debt from banks, it becomes a financial creditor. Why did we even have this issue in the UVRCL case which stressed up the resolution and then RBI had to step in? So these kinds of ambiguities we have to kind of try to iron out. Now coming on to the ARC's things, I just noted one very interesting point. We had a very recent panel discussion with ARCs in ICA's conference. Mr. Pradeep Goyal had come from Prudent ARC. He basically said, like NARCL has been set up to buy loans from ARCs and banks and ARCs are getting hit by that. He said that people don't understand that cash rate is not equal to debt rate, right? They are like, we are ARCs, we are here for margins. Our business is securitization of assets. But when banks want to sell it to us, they expect cash rate. And we try to, this SR model is there because you can't have ready realization, right? So you can't expect entire cash rate, it's a debt rate. So he was making a very particular raw point on this. And one concern which I noted is the tenure of SRs is 5 years. It can be extended to 8 years. Now suppose a situation comes where ARC is a COC member and he's playing a good role, he has a majority stake. And there's a resolution plan comes, and we know a lot of resolution plans have deferred payouts. So suppose a deferred payout of 10 years is there in a resolution plan, but ARCs can hold, SRs are only for 8 years. Then that creates a problematic situation. How do you deal with that?
Which ones have gone back, tell me?
No.
Have you
Correct.
heard of any case?
There are a lot of foreign funders involved. So back and forth trading does happen. In fact, there is trading market for SRs also. This was also very recently known to me. I also did not know. I also believed SRs are not tradable.
It's not transparent.
And not transparent, but there is a market. We have to build it and try to extrapolate and make it much bigger. And second is there is a governance issue in ARC. Again, very recently RBI governor also touched upon this point that ARCs have to buckle up and bring in strong corporate governance norms, because now the feeler is coming there. ARCs are consolidating debt from financial creditor, taking majority voting right, and somewhere the promoter is being allowed to buckle in and come in as a resolution applicant. Somewhere the control is being given to the promoter. Nobody right now is doing a post resolution plan control assessment. Once a resolution is done, somebody takes it over. We don't know who is actually running it after maybe 2 years or 3 years, right? So this is one concern which RBI has highlighted, and maybe a system should work on this also. Thanks.
Mr. Narayan, over to you again. There are RBI frameworks for early identification and reporting of stress assets. What, according to you, is the top concern to be looked at in the pre-insolvency scenario? And what major factors do you notice which affect asset valuation during insolvency proceedings?
Okay, so we'll break this into two parts. On the first part, if you ask me from practical experience, what we have seen is most of the companies we've handled CRP or liquidation in, they have been in insolvency because they could not make their business decisions properly. And if you want to strike at the root of this, the banks, while giving loans, they have to strengthen their KYC norms. They have to strengthen their lending norms. They have to strengthen their assessing of the loan applicants' norms. I have seen cases where loans are given on basis of inflated collaterals or on basis of personal guarantees. We all know personal guarantees are not worth anything, but still loans are given. And it's a very unfortunate situation that end use of finance is simply seen by a certificate issued by a accredited professional. That should not be the case. There should be a rigorous assessment of end use of finance, where that money is being utilized by the company. They took loan for something, but they are not using it there. A very big company we were auditing, they were spending money on luxurious things like revamping offices, this and that, buying Picasso paintings and all. In liquidation, the liquidator was selling those Picasso paintings, but that did not come in use in the business, right? And they did all these luxurious, lavish spending, but when it came to, they were an EPC contractor, and when it came to their core business work, they were underbidding just to get that tender, right? If a cost is 100 rupees, they were bidding at 80 rupees just to get that tender. But it's unviable. And I don't know how banks are, looking at the cash flows, projections, and giving loans on that. Maybe the promoter has very good credibility at that point in time, but that's not how system is going to work. Most of the infra companies, most of the power sectors, again, fortunately, unfortunately, they are all from Hyderabad, most of them which we work on, they are all facing the same situation. Money is not getting spent on the core business, going somewhere else. So maybe that's first thing which should be, taken into consideration, that banks have to improve their lending assessment norms. They have to improve their collateral assessment norms, right? So that's one part of the question. And second, I believe you asked about the challenges in valuation during CRP. There are a lot of challenges, but there are a lot of solutions also which if we work innovatively, we can find out. First challenge, I believe, is standardization. So we have valuation standards issued by ICAI 2018. A lot of talks are there about IBBI coming out with valuation standard. That's still in talks. And the two most used standards are International Valuation Standard, which our code also refers, and one Royal Institution of Chartered Surveyors, which also gives its standards. But there is no standardization. I have to appoint two sets of valuers. And if you look at the asset classes, it becomes 2 into 3, 6 sets of valuers. Now there's a discussion paper. Roy sir was telling yesterday also that that should be brought to the consideration that I'll appoint only 2 valuers. Let those 2 valuers appoint 2 more and let them sort it out among themselves. But RP will only deal with 2 valuers. Now these 6 valuers as on current date, they might be using different methodologies for their assessment because classes are different. You have financial asset, you have land and building, you have plant and machinery. Every class will have different kinds of valuation. Somebody will use cash flow, somebody will use depreciation replacement method, something else also. How do you standardize this? There's no standardization, and right now the concept of enterprise value is not there. So you don't value company as a whole. You value classes of assets, join them together, average them, and you give it to the bankers. So maybe that's one hiccup we have to consider and address. Second is the assumptions the valuers take. That is very subjective. One valuer might look at a situation at a different lens, and another might be very conservative, very aggressive. So that assumption will definitely impact the valuation. Third, which I see is we value as on ICD, insolvency commencement date. Okay. Now, by the time we get information from promoters, by the time we even know the assets are on the books, but they are there physically or not, we might have run even 6 months down the line. And by the time the resolution plan comes, it might be 1 year. So there is a wear and tear of assets or loss of value even in that space from ICD till a date plan is considered. So we have to make up for that. Fourth concern is attachment. So all of our cases, we have seen there is some attachment or seizure by some regulatory authority or some authority like SFIO, ED, PMLA, collector, somebody would have attached some asset. Now we don't even know if you have to take that as our asset or not. Lot of question like attachment was pre-CRP, but it becoming absolute was post-CRP, whether IBC will override or PMLA override, it's all in the Apex code also. So there is a confusion how to value these assets which are under some encumbrance, some attachment, some seizure. Is it even company's asset or not? Even secured creditors who have the exclusive charge on assets are not able to find it out. Some collector comes, he says Revenue Recovery Act, he sells the asset, takes the money, distributes to depositors and goes away. Secured creditors are sitting in the COC. So I think these are challenges which we face practically in valuation. Thanks.
I'll just intervene here because in IBBI we had implemented the registered value and valuation rules 2017, and this was the first time we had tried to get the registered values under some kind of regulation. To Mr. Badri's point about assumptions, a very valid point. So in IBBI what we had tried to do was come out with the guidelines on caveats, limitations and disclosures. So there is a guideline which IBBI issued in 2020 just to have some standardization on the valuation part. And of course, valuation standards, he already mentioned, we had a committee which gave its recommendations, but those recommendations are yet to be adopted. Yeah, thank you.
Now I want to ask a question. Is it really possible to standardize the valuation when you allow them to use as assumptions as you want to have? You have a different methods to calculate the valuation. So when there is so variety of things are available in assumptions and the methodology, so what kind of standards we are talking about?
Even now we have national valuation standards. These are broad standards. It's often said that valuation is both an art and a science. So, but these are broad guidelines, and even now the rules say that national valuation standards needs to be adopted. I think that Mr. Badri pointed out. The idea was that India as a country, keeping its stature, so it should have its own valuation standards.
So if
Valuation, I'll just add, is to put a reserve price. It's not to discover the price.
So just to add on a couple of things. So see, in the Indian profession, valuation is not an independent profession. You can find only very few professions who are dedicated working as the valuation. So their main thought, the main energy would be somewhere else, and this would be considered as a second profession for them. That is the first thing. Second, I believe very strongly that the valuation profession should be carved out from the IBBI and a separate dedicated regulatory body should have been constituted. Couple of years back, somewhere in 2019, there was a draft rules relating to that, but that has never been implemented. So these are the two things on a macro factor that should be looked into to have the more strengthening the valuation profession, which could definitely add more better results in the entire process.
Very rightly said. In fact, when IBBI ventured into valuation, it was just because there was absolutely no regulatory framework for registered values. It was always thought it was an interim measure. And that's why this committee was constituted under the chairmanship of former chairperson IBBI, Dr. M.S. Sahu. So it gave its recommendations on that, and public comments were asked for. And MC, I'm told, got almost 10,000 public comments on that. So there was a lot of debate on that. So that's how it's not, taken. It's not made much further progress on that. I think Ankita is also here.
Now, since we are already
So if
Valuation, I just add, is to put a reserve price. It's not to discover the price.
So just to add on a couple of things. So see, in the Indian profession, valuation is not an independent profession. You can find only very few professions who are dedicated working as the valuation. So their main thought, the main energy would be somewhere else, and this would be considered as a second profession for them. That is the first thing. Second, I believe very strongly that the valuation profession should be carved out from the IBBI and a separate dedicated regulatory body should have been constituted. Couple of years back, somewhere in 2019, there was a draft rules relating to that, but that has never been implemented. So these are the two things on a macro factor that should be looked into to have the more strengthening the valuation profession, which could definitely add more better results in the entire process.
Very rightly said. In fact, when IBBI ventured into valuation, it was just because there was absolutely no regulatory framework for registered values. It was always thought it was an interim measure. And that's why this committee was constituted under the chairmanship of former chairperson IBBI, Dr. M.S. Sahu. So it gave its recommendations on that, and public comments were asked for. And MC, I'm told, got almost 10,000 public comments on that. So there was a lot of debate on that. So that's how it's not, taken. It's not made much further progress on that. I think Ankita is also here.
Now, since we are already talking about valuation, there is a very recent judgment of the Honorable NCLAT of Canada Global versus IDBI Bank, which is further affirmed by the Honorable Supreme Court in M.K. Rajagopalan's case, wherein one of the key aspects which was pointed out was the importance of the valuation report, rather a thorough valuation report. Now, my question in that aspect would be, Mr. Ahuja and Mr. Narayan, how does a well-built valuation report influence the overall decision-making process of the COC? Further, what are some key challenges faced by the valuers while conducting valuation, especially when the information provided is either limited or incomplete?
So see, you already bifurcated this in two parts. So let me start with the second part first. See, resolution is a creative work. It's even in one of the event, IBBA chairman has mentioned that the IPs needs to think outside the box to get the resolution done. Whereas what, as a valuer, we are realizing the IPs are not even taking the responsibility of the data that they have received. Yes, there is a limitation, there are non-cooperation, this is going to be there, this is going to be their lifetime, undoubtedly. My request to the fellow professionals to own that data, take the responsibility and at least enhance the value of the data instead of just passing it over to the other professionals to work on it. That is the first thing. The second thing, the challenges that going to be faced, I suggest to have a more interaction between the administrator, resolution professionals, the valuers, and specifically with the COC members. In terms of the understanding of the availability of the data, in terms of the availability of the similar data sets with all the stakeholders, and then the understanding of the macro environment relating to the corporate data. The more interaction that has been done with the COC member, it will bridge the difference between the data asymmetries between the different stakeholders. So these are the key points that I would like to highlight. Yeah, please.
So, like you mentioned about a judgment, see, valuation, high courts for times immemorial have held that it's a subjective thing. You can't question experts, competence. So, if valuer has given a report, he has the competence, he has the skill set, he has given the report. And Roy sir was also telling about an independent valuation standard, independent professional, all these things should be there. Some practical anomalies which we have been noticing. I'm going to say things which I'm not saying, okay? So, it's like I've heard bankers asking whether we can ask the valuers to up the value a bit so that we can negotiate with the resolution applicants. And I'm like, first of all, you don't disclose value to resolution applicants. Very recent amendment, only fair value can be disclosed. If you disclose fair value, anybody, Tom, Dick and Harry can do a discounting and get it at liquidation value. They will game the system. In fact, initially, IM used to have fair value liquidation value. Then they removed it. Now they've again introduced fair value. So first of all, you don't disclose it to the RA. So why do you even want to say that you want to negotiate based on that? Second, if you even up the valuation, suppose valuer gives 100 rupees as the fair value, but the RA still does his due diligence, which is an obvious fact, and he says this asset is worth only 45 rupees. Now, will your internal board approve a plan which is at 45 rupees? So, by upping the valuation report, you are going to make a situation which will backfire on you. Your internal board itself will blast on you that I won't accept a plan which is below 100 rupees valuation because there's a report on it. So, these kind of, thinking is going inside the system. Second is, unfortunately, maybe the system has been developed like that. You have valuers who can do it, do your valuation for 5,000 rupees also. This I am telling from disclosure of cost which is published in public domain. 5,000 rupees, 10,000 rupees, SFS are being valued. I think like we have now schedule 2 for RPs, fee is fixed based on the claim value. Something should be there for the valuers also. You can't let this become a competitive bidding mechanism where professional quality is being reduced. You can't expect a good valuation at 5,000 bucks, no matter what small the company is, right? There are definitely some proposals from IBBI that for MSMEs or companies with asset less than 1,000 crores, valuation might be done by one valuer. That's a good idea. Maybe go ahead for that. But we can't allow these kinds of anomalies to get into the process. Now, challenge is, sir said, information does not come. Correct. But code says you have to physically verify the assets. So RP should go with the valuers, do a physical visit, see what's available, make a list of that, and value can be arrived. And where you don't have historical cost, that is fine. Any valuer, any technical expert, by seeing the asset, by seeing the plant machinery, can make an estimate that this must be from this year. They can research on the model number. For land and building, you do a circle inquiry, circle rate inquiry. Things can be done. So problems will be there because evolving code, lot of stakeholders, everybody's interest is affected, lot of influence keeps on coming. But RP and valuer, integrity, independence, we have to keep it at very high stake to make sure the process is fair. And nobody should try to game the system. Thanks.
Now, there have been certain instances where I've heard that the COC is presented with multiple valuation reports. Forget being at par, they're not even the same. Mr. Ahuja, considering you're on both the sides of the coins, you are a valuer as well as an IP. How should the COC approach situations where multiple valuation reports are presented? And what is the correct way of ascertainment?
So I will see there are 3 critical factors that the COC member should look into. First, which I mentioned earlier also, the similarity of the data that has been used by the valuers, by the 2 different valuers. The another one is the approach that they have followed, whether they have followed the same approach. If they have not followed the same approach, it means they both have a different understanding. And whether that understanding means as a commercial thought of the COC member and the resolution professional also. And the third, which Badri has mentioned earlier, the assumptions that has been used by the valuer. There should definitely be a limited range of the assumptions that has been used instead of a very, very different assumptions that is being captured by the respected valuer, if the COC member can point all the noise and all the numbers around these three things, they can easily able to gauge what is the right solution for them, what is the right number for them, if not the exact number, but definitely a range in which they can take a decisions for the approval of the resolution plans. Yeah, Badri, you want to add something?
No, I think we covered most of it, sir. So again, this all comes to the numbers game. Some fields up the numbers, get better plans. Some fields, make the numbers very low so we can make our intern boards happy. And somewhere resolution applicant also will get his own valuer, he'll do his own valuation. So only if you do a fair process, and you have to be very conservative when you do a valuation. You can't expect stars in skies when you are having a stressed asset, which is not running for 5 years. You can't say the asset is in perfect condition, this and that. In fact, a very good thing which has happened is the amendment says valuers should be called to a COC meeting where they should be allowed to discuss the valuation methodology with the COC members. That helps a lot because this is before finalizing the valuation report when the estimates come. Estimates are not shared, methodologies are shared. If the COC members really are proactive, they understand the company to whom they gave loan to, they will be able to tell the valuer this is not the right methodology. They will be able to tell what difference will come if you change the methodology, right? That discussion should happen, which is not happening, and we look forward to those things getting captured in future.
Actually, the COC members use their commercial wisdom while talking with the valuers. They are specialized in their field. The COC members are also having their own valuation over it by their own methods and by their own assumptions. So on these parameters, if they compare their valuation with the valuation of the experts, then majorly the result will come. And if they have any doubts, the meeting is planned for the same purpose that the doubts can be solved, and the further, if there is some significant difference between the values of themselves and the presented experts, then another valuer may be appointed for the group of the assets or for the specific asset.
Continuing from the same question, Mr. Deora, taking your wide expertise into consideration, in cases wherein the adjudicating authority is presented with multiple reports to decide from, what in your opinion should be the correct model of adjudication?
Well, first of all, the adjudicating authority should not get into deciding on valuation, in my view. There's enough material available with the lenders and the borrower about the previous valuation reports from the time the business originated or the loans were first drawn. So those reports should first be seen as to what all was captured, methodology used, and how the loans were given. And is that consistent with the methodology now being adopted? To that extent, yes, adjudicating authority will be completely within its right to examine something like this and reach a conclusion. I'll tell you a case I know of wherein there was no fixed asset register. List of assets is given to me by the managing suspended directors. They said these are the assets. There was no way I could have collated anything because there's a fire, reportedly, before CIRP. I go to the banks and we look at the ROC records and we try and discover what are the assets which were hypothecated, mortgaged, what are listed with them. And we went to the different valuers reports also, who had done the valuations at the time of creation of charge. We found some differences, so we then approached the valuers which were old valuations. I said, look, gentlemen, you did this and you did this, and please can you clarify, do you have working papers? And we received the working papers, and we drew some analysis from there, put it up before the COCs or the SCCs, and the decisions were taken after confronting the management that this is what the position known to us is. Would adjudicating authority do so much? At least it could see the working papers. I had long back done a valuation when this profession was not there in a merger, and the High Court called, asked the lawyer who was representing the matter that I'd like to see the valuer and the working papers. So I went to the Delhi High Court. That time the NCLT or CLB process was not there, and the company judge asked me that, where's your working paper file? I said, no, here's the file. So I said, is there something specific I need to present? He says, no, okay, that's fine. So there was a working paper file which the court looked at, and it came to properly a prima facie conclusion that this man may have done work. So what would adjudicating authority see, I don't know, but they cannot go into too much of details. Nevertheless, methodology is something which is very important. Now, what is a value? I must add here something I learned more than about 30 years ago. I was representing a client in a transaction to take over a company in the UK, and we offered price X and we lost for price four times X. So I went back to this merchant banker, Gopal Finance, I remember the name, right at the corner of the Bond Street, and I said, why do you think we lost out? We had a good price. He says, your difficulty is that you were trying to offer something what you think the seller should be getting. That's not the value. The value is what it means to you. And the company that bought it can probably recover that value in 2 years, and you did not have a plan to recover that value quickly. So I applied it to a situation where we had a motorcycle standing in a factory, and this was built at a cost of about 15 lakhs, a Royal Enfield, which was redone with huge tires and made a mantelpiece of the factory. There's no way we could have sold that motorcycle for anything like even 5 lakhs or 4 lakhs, because the motorcycle is worth dilapidated, 30,000 rupees. So we went to one of the motorcycle dealers, I sent one of my boys there. I said, just go across to one of the dealership guys and just tell him that we have this lovely motorcycle and you could probably put it in your showroom. So he was very excited. He was a Royal Enfield dealer, and he bought that motorcycle for 3.5 lakh rupees. The banks were very happy that how could you get this? Those small amount as opposed to the debt, but you have to find where the value lies. So one, A would have to look at the previous reports, look at the methodology, the process adopted to value the assets. What was identified as the assets is very important, which they must look into. The tangible assets is not the only thing, they're intangibles. Somebody just mentioned about an EPC company. So in a company where I was involved, the fixed assets were worth about 4 crores, but the resolution plan finally came in for 32 crores, and I'm sure the successful resolution applicant would make more than 100 crores out of it over the next 7 years from the time approved. Because what we put to valuation was the arbitration going on, awards, the litigations which are going on, were all put to valuation. They were challenged by one of the PRAs before the adjudicating authority, who wanted to know that what methodology would have been applied to value these litigations, which was explained, and the order was dictated dismissing the application. They said reserve price, basis this valuation mechanism adopted, is correct, and the banks then, the valuers who were involved, they got some seriously large amount of work from NHAI for valuing the claims. This order was challenged before the appellate authority, and the appellate authority dismissed the appeal, holding that the valuation was correctly carried out, taking into account the awards and the discounted value of awards. Mind you, the platform which is now being developed to discover values is a good one. We tend to, get everything concentrated with the regulator, which is what is happening. But if somebody takes a note of this fact, there's a company called Soteria, Soteria. It's an Israeli friend of mine who's got this company in New York, and he sells not readily realizable assets. So he's got a mechanism in place which puts the transactions on the portal. Interested people can log in. There's no prices, no names known. If you're interested, then they will start doing the matching for you. Because globally, these assets have a lot of value. So I'm talking of other than fixed assets. You have Demonor, you have Omni Bridgeway, you have these large companies which only work on litigation recoveries. So there's a value in them. What methodology you adopt to value these kind of assets or these kind of recovery or potential recoveries is very important. Of course, adjudicating authority will not start valuing, but should prima facie look at the process adopted. If I have 2 minutes, I can just narrate something which I've had some harrowing experience for the last 6 years, still going. I don't know when it's going to finish. One of the pieces of land was being put to industrial use in a prime location and being purchased by this company in 1960s. A conversion was obtained, money was never paid for conversion. Now the valuers valued this as agricultural land. Reserve price of agricultural land is X, industrial land is 5 times X at circle rate. The circle rates are 1 to 5. Reserve price was placed somewhere between 2.5 to 3 and was put up for auction. The process got challenged before the adjudicating authority, which held that the valuers and the RP or the liquidator would be in breach of professional duty if they valued this land as industrial and auctioned that as industrial, because the conversion charges were never paid for a period of 40 years or more. So that is on as is where is basis. So the appellate authority upheld the order of the adjudicating authority, went to the Supreme Court. The promoters were, still litigating, and they said, look, this land is worth 5 times the value it has been sold at. So the bench, this was like a few years ago, so the bench said that you have a buyer, you get us the buyer. They said, no, allow us to buy it. I said, no, not you, get us a buyer. And they placed a price which was about 20% or 15% higher than the reserve price. They said, if somebody comes in, he must pay something more. It should not be upset for 1 rupee. And they said that you will get a buyer as industrial property. And he would deposit 25% of the money with the Supreme Court registry. If he doesn't come forward, money will be forfeited. And then he'll put into an auction with an existing, the bidder, who's a successful bidder. They tried all ends up for a few months, took a few extensions from the court. Ultimately, they couldn't find a buyer who would buy this as industrial land. So the action was upheld. Not the end of the story. This is part 1. Part 2. The order comes from the Supreme Court on, say, 10th of a month. On 11th of the month, the municipal corporation raises a demand saying that you owe so much of money for conversion charges. Fortunately, before the Supreme Court decided, the municipal corporation, the Director of Town and Country Planning, the municipal, authorities for revenue, which is the Tehsildar and all, the administrative authorities were all given notice by the Supreme Court to ask from them, to inquire from them that was this property ever converted? Because it's a huge transaction. Everybody came back, no, it was not converted except municipal corporation. That we have some records that converted in 1972, amount was payable, never paid. So the court said that, do you want us to impose on you charges for illegal use of the land? Who would pay that? You don't expect the corporate debtor to pay it because you've come to the court saying the land is converted. Anyway, they withdrew silently and municipal corporation claim was dismissed. I didn't accept it. Their application against, their appeal against my claim rejection was rejected. Appeal was rejected. Supreme Court rejected that appeal, civil appeal. A review against that was rejected. Now, basis the fact that this is part 2, this is part 3, this is part 4 which is going on, which is separate. So part 3 is the promoters now rise again from their own ashes and say, look, municipal corporation considered this land as commercial, had raised charges, and therefore this land is industrial, was incorrectly sold, and should be auctioned another time by setting aside the previous sale. In the meanwhile, the sale deed has been conveyed. The certificate of sale issued, registered. Now again, the adjudicating authority comes in, they dismiss that application. Appeals are dismissed because there are 2 promoters. Both appeals are dismissed. Supreme Court dismisses the civil appeals. The review is dismissed. Now they go to the revenue authorities. They said, please do not release the certificate of sale because of the dispute going on. So there's some inquiry carried out by the state authorities. They said, no, this land has been correctly sold as agricultural. It could not be industrial because it is Gair Mumkin, registered as Gair Mumkin, it's not been taken off the revenue records. That still is not complete. Now, the land sold, certificate of sale issued, the bidder has done a development agreement with somebody, with a developer. That development agreement is not getting registered now. So life is not over. I don't know where it's going to finish or when I would get out of it. I hope there is some hope for me.
Quickly moving on to the last few questions that we have.
Just to add, the Gair-Mumkin issue is pending before the Supreme Court to be decided that whether any development is possible, leave alone agriculture.
Right.
So Gair-Mumkin is also not agricultural.
No, Gair Mumkin is also not agricultural, but then it must go out of the revenue records.
It will not go out of the revenue records.
So it will not go out of the revenue records.
No, to become industrial, it has to be taken off the revenue records.
No, what I am trying to say
Yes.
is that it may be recorded as an agricultural land. After that, nothing is possible. Therefore, there is an old nomenclature by which it becomes Gair Mumkin. Gair Mumkin, nothing is possible.
No, I'll tell you a recent piece of knowledge I gained in a matter. When you have a boundary wall across a land, even if you're doing agriculture, they recorded Gair Mumkin because I discovered in Punjab on a recent application which I had to then move before the DRT that you made it Gair Mumkin. They said, collector office tells me we made it Gair Mumkin for purposes of stamp duty when you sell it.
Okay, so for
There's something additional.
stamp duty is a separate legislation. It is a state legislation. Insofar as this part is concerned, revenue records are only for the purposes of getting revenue out of the land, no revenue is collected for those lands 200 years ago, which became Gair Munkin.
Right.
So Gair Munkin means that agriculture is not possible there. If agriculture is not possible, but for the revenue records, one of the columns will still continue to record that it is for the agricultural purposes, but no revenue is connected for the reason that nothing is possible.
No, revenue is collected, sorry to just, make another statement.
There is a lot of confusion on this, and ultimately the government of Haryana has not been able to understand, and several other governments have not been able to characterize and understand what this expression actually means.
So revenue is collected on the basis of use you put it to.
Sir,
So there be house tax if there is a building.
No, sir. What happened was, insofar as agricultural land is concerned, or the land which was there, till about Akbar when he ruled, this land was, everything belonged to the king. Then Raja Todramal came and he said that we will do some kind of a land, we will put some kind of a method to that madness. But that did not convey the title. It only said for the purposes of Mansabdari system and the other systems for the purposes of collection of revenue from that land. And they said that that land is there, but it cannot be cultivated, but it is Gair Munkim. So some category came into the being that don't put lagan on me for that purposes. Now the issue is whether the Gair Munkim land can be converted. If it cannot be used for agricultural purposes, can it be used for purposes other than agriculture? So this limbo continues, and this nomenclature has created an havoc. Sorry, that's
Thank
my
you.
2 cents.
Okay, so quickly moving on to the last few questions. Let's jump on to the very reverse, which is which is the information utility once again. Now, of course, there are number of insolvency professionals in the audience, sir. Now, my question to you is, what's in it for the insolvency professionals? How NeSL is as effective for IPs as for creditors?
Okay, we had some discussions on history, geography, valuation, and legal. What else? So last week there was a Insol seminar in Bangalore, and I was asked to speak on the topic of information utility and Indian innovation. And if you see the website of IBBI, it says that information utility as an institution has no parallel anywhere in the world. So it's an Indian innovation. You said that what is it there for IPs? Now, information utility is not a public credit repository. Access to the repository is as provided in the code. It's limited to certain persons, authorized persons, and IP is in a privileged positions in having access to the information in the information utility. How is it beneficial for the IP? Ankita used the word about transparency. Now, any information which is submitted to the information utility is immediately presented to the debtors who have the right to accept or dispute the information. Today, most of the time, debtors don't respond. In fact, the proposed amendments to the code, which is there in the MCA discussion paper, one of the proposals is that it will be made mandatory for the debtor to respond. I'm not sure whether that proposal will see light of day, but one of the proposals is that it will be mandatory for the debtors to respond when an information is submitted to the repository and the repository presents it to the debtor for his consent. But even as we stand today, any information which is there in the information utility has been presented to the debtor for his comments. And if he has not responded, one can assume that it is undisputed information. So from that perspective, IP gets information about the CD presented by the various creditors, and the creditors, if they have disputed, it will be there, it will be recorded in the IU. If it is not there, he can assume it is undisputed information. How he can use it? He can use it to compare it with the claims. He can use it to see if any creditors have not submitted their claims as part of the public announcement. This can reduce unnecessary litigation, it can avoid unnecessary litigation. He can have access to contacts of the creditors. He can have access to the security details provided by the debtor to various creditors. And one last aspect and important aspect is that he can also store his records in the information directory. I was seeing a recent disciplinary order of IBBI where the IP, one of the allegations against the IP was that he was not able to produce the records when asked to do so. Of course, his response was different, but the fact is, and one of the reasons he gave was that the server where it was stored, that had some issues. So why not take benefit of the information literacy, which is a regulated entity of IBBI? Sometimes IPs tell me that, look, why should I do online storage when I can simply put it in a hard disk and maybe put it in a bank locker? The difference is that storing in a hard disk can get corrupted. Moreover, you have to store it for 8 years. 8 years, the interface itself could change. Sometimes then the IP told me that, look, there are other online forms of storage. There's Google, there's Microsoft. But we have done a comparison. And we have shared this with the IBBI. I will shortly maybe make it public also. If you see the kind of services which we provide, it is cost effective. It is comparable. The cost is comparable compared to whatever other service providers, depending on what is the kind of service you're getting. And one benefit of online storage is that it doesn't get corrupted in the sense that we have a DCDR. So information is available and information can also be provided for third parties. Suppose information needs to be required to some law enforcement agency. So through an online storage, this can be very easily provided. In a physical storage, it could be very, very tough. So that is one part. And other part also, we have an integrated case management system. And it is fairly popular. We can do it in all the processes which the IP does can be done in a fully digital manner. Of course, with the integrated technology platform being launched by IBBI, so this may soon be defunct, but till the time it is launched, this facility is also available for use by IPs.
Now completely switching off from valuation, stressed assets and information utility. Ms. Sharma, taking your role into consideration, the IBBI plays a pivotal role in the insolvency and bankruptcy ecosystem. In your opinion, what more do you think the IBBI should be doing, or what further steps or enhancements could be brought into by the IBBI for effectiveness of the framework? And also, what do you think of the correlation of IBBI with the adjudicating authorities to make the framework stronger?
Yeah. IBBI says that 6 valuers are necessary for valuation of assets in different category. Valuation rule says 1 valuer is sufficient. Let's have a 2 group. Now, how can we compare the expertise of 6 with 1 or 2? Now, if we talk about the cost, obviously the 2 will be more cost effective than the 6. Now, what is more important for us? Cost effectiveness, timelines, or the actual valuation which actually saved the company, which actually saved the livelihood of many, as per Chaudhuri sir, because the valuation can impact the future of the going concern. Now here it is very important. I'm very fortunate to say that IBI took the cognizance on this particular aspect and have issued a discussion paper and finalized the issue that 2 valuers are okay, and if they feel that some expert views are required, then the valuer is free to take that particular decision at his own. Now, moreover, why the suspended directors, why the promoters are not supporting the valuer in getting the documents, in helping them in finding the data and in valuation process? Maybe the situation is very threatening that maybe, this is my observation while working in various committees in the IPA, that maybe the promoters have all the information. They want that some of the assets will go into known, readily realizable asset, NRRA, And later, when the process is complete, they will buy it at throwaway price and encash it. If this is the motive behind the non-cooperation, then it is a threatening position for IBBI, for the whole ecosystem of the IBC. Moreover, when the information is very important, when the information utility take 30 days or 60 days to provide the information, when the RP or IRP take 7 to 47 days to appoint the valuer, then why we expect the valuer to submit its reports in 30 days? Matlab, in my opinion, the valuer is like a Shah Rukh Khan of a movie. On his performance, the success and the failure of the movie depends. The same is with the IBC code. If the performance of valuer is not good, the future of the company is not in a good hand. So, in my opinion, the efficient or I can say that whatever time he want, the exact time should be provided to them so that they can give the good valuation report, reasonable valuation report, and the smartness of the creditors can be maintained by not giving the much haircut to them. This is one more thing which I expect from the IBB, that they should make some stricter regulation for non-corporation of the suspended board of directors. Moreover, we can demand for a separate bench for asking for settlement of the cases under Regulation 19 and the Regulation 37A of the liquidation. Thank you.
Moving on to the very end of the session, I just have 3 concluding questions which are open-ended to the panelists. How can we attract more investors to participate in the resolution process of the stressed assets? I'll repeat the question again. Just how can we attract more investors?
We got it. Because we had the questions with us. Right? So before coming to that, on ma'am's point, on the non-cooperation, we have section 29A to make, filter out people who cannot come and participate, right? So maybe just a thought-provoking thing, that a non-cooperating promoter against whom a section 19 is filed and an NCLT order is there should also not be allowed to participate in a resolution plan process. Maybe that will then make him a bit apprehensive and he will start cooperating from the beginning itself. Maybe just a thought process. Second point is, ma'am, आपने बोला कि शाहरुख खान है valuer and all, but we don't want 5,000 rupees Shahrukh Khan coming and doing some performance which disrupts the entire process. That creates a lot of harm for the process also. Coming to the question, see, if you talk about like judicial precedents per se, there are so many, but I'll stick to one: Maharashtra Seamless, Padmanabhan Venkatesh versus Maharashtra Seamless, because I personally handled that case. The corporate debtor was United Seamless Tubula. It was a company which made oil rigging pipes. You rig pipes within deep sea and get oil. And in that case, what happened is RP appointed 2 valuers. There was large difference, and you did not have this 25% thing then. It was a 2018 case. So because there was a substantial difference, a third valuer was appointed. The closest 2 were averaged. A plan came, which was below the liquidation value, of course, and then it was approved by the COC majority. Went to NCLT. NCLT approved the plan, saying that okay, the plan value is lower than liquidation value, but COC commercialism and K. Shashidhar case was there. They approved the plan. Went to NCLAT. And again, fortunately, unfortunately, that time NCLAT was giving very divergent judgments, and it literally shaped IBC to the thing which we have today. It's thankful for that. NCLAT said a plan cannot be lower than liquidation value, and it said you don't. So we average second and third valuer. NCLAT said no, you value first and second, and then take the money, extra money from the resolution applicant. Some 120 crores difference was there between liquidation value and plan amount. So NCLAT exercised its judicial activism and said to resolution applicant to pay 120 crores more. Now investor is an investor. He's not here for charity and he's not here to throw away money. He went to Supreme Court. The promoter of the corporate debtor was fighting for the asset. He also went to Supreme Court, right? And one of the minority creditor who was along with the promoter, because of some reason, he was also in Supreme Court. Now ultimately Supreme Court laid down the law that the court does not anywhere say that plan should meet liquidation value. Sir was telling that valuation is for reserve price. He's right, reserve price, but not benchmark price. That this is not the price at which asset has to be sold. It can be for more, it can be for less. It all depends on what the asset quality is, how the plant is, its operational or not. A lot of factors are there. Ultimately, it's a buyer and seller's market. It depends on market dynamics. Supreme Court said the court does not lay down this, and courts, NCLT and CLAT should limit their intervention in these matters where commercial wisdom has been exercised. Also, valuers, a subject matter expert, has done his job. So that has freezed the parameters there. Now, all we want is valuers' competence should be built up. Like we talk about capacity building for IPs, valuers' capacity has to be built up. Independent body should be there. Standards, nationalized standards are required, and consistent parameters. And one very good point is the caveats and disclaimers and assumptions should be narrowed down. You can't completely wipe them out. There will be subjectiveness, but it should be narrowed down. Maybe some parameters can be fixed by IBBI or RVOs. Yeah, but it's still a lot of fluidity is there, sir. I cannot be stopped as a valuer from putting my own disclaimers. So I have a case where two land and building valuers are there. One says, I'll value this entire 100 acres of land at one rate. Other one says, 50 acres is closer to a highway, I'll value it higher, and 50 acres is somewhere in the back and I'll value it lower. I can't stop that valuer from doing that. He is justified in doing that. He has his own assumptions. So somewhere maybe some standardization can come in when we get the national standards on valuation.
I know it is lunchtime, sorry to keep you waiting. Just last question, concluding. What role can technology play in streamlining the resolution process of the stressed assets? Technology.
So I'll just give you a background. We already have a digital document execution platform, and which digitizes the entire process of documentation. And now in the budget announcement, we've heard of this integrated technology platform. So idea is that all the disparate systems will speak to each other. What are the systems? We have NCLT, we have IBBI, we have Information Utility. So the entire, all the systems will speak together, and it will flow, information will flow from each system to the other system. So there will be one single entity registration for each of these disparate entities. So this is part of the proposed technology platform, and idea is that information will flow from each of them. For example, if there is a resolution plan has to be submitted to the A, so the same platform can be used for the IP to work on the CIRP. Once the CIRP process is complete, so this platform can also be used to upload the resolution plans to the A. Similarly, at the admission stage, when NCLT looks for the record of default, so through an API, it will access the record of default from the IU. So the entire process is supposed to be streamlined. Systems will speak each other, and one very important point, which Honorable President made in one of these colloquiums. Today, NCLT is facing a huge challenge of paper. Tomes of paper are coming, and there's a challenge of storing them. So idea of this system is to make it entirely paperless. From the application process, from the application filing process, then information will flow to the IP, because IP will also have that registration. He will do the CIRP also on the platform. It will get completed. From there, it will flow to the NCLT. NCLT will be able to access all the data. It will correlate with the original application. It will see the resolution plan. Resolution plan will also get approved. The orders will also flow through the system. So that is what is envisaged in the integrated technology platform. I'm sure some of you would have also heard of this IBC 21. It was supposed to be model of MC 21. But now I think since the government has taken charge of this and it's come up in the budget announcement, so this is, I think, will take precedence. So it's a beautiful system. It'll be a fully complete technology pack. One need not go anywhere. And as I said before, all the disparate systems will speak to each other. And one important consideration which went into designing the system was that a data which is put in the system, it will be put in only once. So for example, if you are taking claims online, so then subsequently that data remains in the system. It gets processed. And you don't have to again do the data entry for that. So the idea is that only one time data entry, paperless processing, and all the systems speaking to each other. So it's a seamless journey for the IP.
Thank you, sir. Owing to time constraints, I am bound to intervene. Never. Okay.
As an insolvency professional, to have any utility, so that I can use your utility, and all the e-form required by IBBA to be submitted, that can be done automatically?
Okay, so that's one interesting point. And, I think you're referring to the fact sometimes at the time of inspection, you have to submit volumes of data, right? Yeah, so see, in this system which we are doing, as I said, data entry has to be done only once. See, today when you are filing these CRP forms, you have to go to the IBBA website and put in the data, right? So as I said, you have to put in the data only once. After you put in the data, everything the system will do. So all your forms will get generated. I said earlier, the systems will speak to each other. So once your data is ready, then you want to submit the forms. So forms will be automatically and seamlessly submitted. Data you have to submit only once.
Will you be integrating AI with this?
No, that's also a possibility. So AI has multi dimensions, right? AI could be used to identify default. See the trends in the borrower's account and see what is the trend. Is there a possibility of default in future? So that's a potential use case of AI. So it could be used in various ways. But as of now, what is being planned in this platform is that, these three things. Data entry only once, paperless, and systems speaking to each other. So if you want to submit data to IBBI, it goes from your system. All IPs will have access to the system. So data will flow from you to IBBI. If it's a CRP forms, it'll from you to the AA.
It must have a general chat GDP and it must have a specific AI application for it to be idiot proof.
I'm sorry
Yeah,
to
it's
cut your
always a possibility.
conversation, sir. Let's continue our conversation during lunch. I thank the panelists for such an insightful and engaging discussion. I'm sure we would further delve into these topics. And of course, I cannot miss saying that I'm fortunate to have moderated such an eminent panel. Thank you so much. Thank you.
Thank you to the